Is it possible to get divorced from your incompetent or disabled spouse? And this is a topic that doesn't come up all too often, but was a situation that we had to address for a client several years ago. I'm Carrie Jacobson of Jacobson Family Law, where we keep the drama out of your divorce. In this particular situation, the parties were having some marital difficulties, and then husband had a stroke. Unfortunately, the stroke left the husband cognitively impaired. For several years, wife took care of husband, handling all of his medical procedures, taking him to doctor's appointments, and anything that he may need, in addition to caring for their 3 young children. After several years and getting husband stable and everything associated with a medical malpractice claim taken care of, wife decided to move forward with a separation and divorce. In order to move forward, we first needed to know whether or not husband was capable of making important decisions such as financial negotiations. So we first had him evaluated by a neuropsychologist to determine whether or not he had these cognitive abilities. After the evaluation determined that husband was not competent to make these decisions, we then needed to have a guardian appointed on husband's behalf. So a family member of the husband was ultimately appointed to be the guardian of his person and his property to make decisions on his behalf. With the guardianship in place, we were then able to negotiate on behalf of our client with the guardian and his counsel. Ultimately, our client was able to negotiate an agreement that she felt comfortable with the guardian of her husband, and then finalize the divorce. Because of all of these complicated factors, it took longer than normal and probably took about 2.5 years to finalize the separation and divorce process. So if this is something that you have encountered or would like assistance in negotiating the agreement with your spouse's guardian, contact us today and we would be happy to help.